to the portal.
Right.
So we've got it.
Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents.
Let us pause at this point. The court is undertaking a standard yet critical procedure, appointing legal counsel and continuing the matter to a later date. This action effectively pauses the procedural timeline to allow the defense adequate opportunity to review discovery materials. In practical terms, it is designed to prevent unfair surprise at trial and to preserve the integrity of the proceedings.
Considering that their first duty is to the state.
I understand. We've had this conversation before.
Conflict of interest. And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here.
This is a stage every courtroom observer should carefully note. The court is outlining the significant risks associated with self-representation. Such a decision is not merely unwise. It may carry serious legal consequences. Trial litigation operates within a complex framework of procedural and evidentiary rules, and without proper legal training, even a potentially valid defense can fail due to technical missteps.
Here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So
the proceedings now move into what is legally recognized as a FARETA inquiry. This formal examination ensures that a defendant knowingly, intelligently, and voluntarily waives the constitutional right to counsel. Although the court's questions may appear straightforward, they function as essential constitutional protections designed to safeguard the defendant's rights.
I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I know we've been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud.
At this juncture, the tension increases. The defendant indicates a lack of understanding regarding the applicable sentencing range, which presents a significant legal concern. A valid waiver of counsel cannot occur unless the defendant fully comprehends the potential penalties involved. The court's intervention, therefore, is not a restriction of personal liberty, but a measure taken to avoid reversible judicial error.
Just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I have no idea anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding.
Observe the change in judicial tone. The court transitions from providing clarification to rendering a determination. When a defendant repeatedly demonstrates confusion about fundamental legal consequences, the court is obligated to intervene, even over objection, to ensure that the proceedings remain lawful and constitutionally sound.
I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case.
I don't know when Mr. Jeffries on my.
I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff.
He's not on my case.
Go back with the bailiff.
He's not on my case.
Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury.
Right, I would
And
assume.
we'll just get it figured out that way. All right.
Thank you, Judge.